say, which is not on the same plane as the original statute which conferred jurisdiction, आप right of appeal provide कर सकते हैं, considering that it is a substantive right. So by sub-constitutional legislation, can you exercise the same powers as are envisaged in the Constitution, i.e. creating a right of appeal?
My lord, your lordship,
Ignoring the fact that the instrument that creates the jurisdiction does not provide an appeal.
my lord, I think the instrument which creates the judicial forum in the first place is irrelevant. The issue is whether that particular provision has a bar to creating such an appeal through an ordinary statute, number one. Is there any bar in Article 185 that such intra-court appeals cannot be created? What I'm trying to understand, where does this bar come from?
From the language itself, subject
Which
to the
language?
Constitution and the law. You see, you're relying on this language to say this is enabling and this gives competence. But there are other language where the Constitution gives enabling powers to Parliament and gives it competence. It's totally different language. So you are not creating any difference in that language. You are not saying that where the Constitution is saying it may by law or it may by or under any law, which is a direct power that it is giving to the Parliament, you are not making any distinction there. You are just saying read competence into the word law. The word law has been used over 400 times in the Constitution. Do we read competence into every time the word law is used, or do we now start distinguishing यहाँ law का कुछ मतलब है, यहाँ law का कुछ और मतलब है? That's why for interpretation you follow principles. So which principle are you following? And on what principle will we be able to say in the next case and the next case that this is the principle that we followed?
I think these are two separate questions. Your ladyship is still on the question of competence. Justice Ejaz has asked a question regarding procedure. These are two separate questions which should not be
separate. It's the same, and it goes back to Justice Shahid's question as to the manner in which any change in the jurisdiction given by the Constitution
Where is the bar in the Constitution which says that the
175,
constitutional forum created by the Constitution bars the statutory remedy? Where is the bar?
Acha, can you cite any example where the jurisdiction creating statute does not provide an appeal, and by way of subordinate legislation an appeal has been provided?
Lord,
Or to extend the example further, through another statute which is not on the same plane, an appeal, a right of appeal has been created.
my lord, your lordship doesn't have to go to statute and rules. Your lordship just has to look at constitutional forums
That is
and intra-court
precisely the
appeals.
point.
Intra-court appeals.
That is precisely the point.
I think 270, Article 270 is answer to the question where the constitution maker has upheld the jurisdiction of the parliament to enact by providing appeal to the Supreme Court. देखिए इसमें 270 में प्रोटेक्शन दे दी गई है।
No, but
इसका मतलब है उसको
the question is different. The question is
ये है ना कि उसमें वो अपील की रेमेडी दे दी गई है,
where
उस अपील की रेमेडी को अपहेल्ड कर दी।
My brethren, to let's one speak at a time.
where jurisdiction has, original jurisdiction has been created, conferred by the Constitution. Can sub-constitutional legislation interfere in that and
Yes,
extend
if there
it?
is no bar and
No,
it cannot.
there is a bar. The bar is item 55,
And there is
which says express authorization. Now we have repeatedly asked you, where is the express authorization? 175(2) doesn't cut it.
My lord, I have
No, but
stated
Mr. Faisal,
170.
during the break, I went through the LPG Association against, and I stand wiser actually. I think 175 could grant that authorization.
Yes. So that is, I've stated that. I take your lordship's point. Maybe I will elaborate it when I come to your lordship, and I have the very difficult task
Okay.
to argue against the judgment.
Please proceed.
Please read to
With a very heavy heart.
Article 270, please read it.
जी 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 सर। फिर मैं move on so that I finish, sir. I know your lordships are temporary validation of certain laws.
As a side note, since you represent a political party, did anyone vote against this, any political party vote against this law?
Sir,
If you don't know the answer, you can give it later.
Attorney General, मेरे ख्याल में
no.
Senate में PTI वालों
आपके clients बता सकेंगे ना?
नहीं, मेरे clients ने तो voted for them.
नहीं, actually,
Yes, I can ask them, sir.
ठीक है,
I didn't
okay,
ask.
okay,
Sir,
continue.
I'll move on to the next, but I'll come back to, and your lordship's question was.
270. ये आर्टिकल 270 आप पढ़ रहे थे।
जी, sorry. Majlis-e Shura may by law in the manner prescribed for legislation for a manner impact part 1 of the legislative list validate all proclamations, presidential orders, martial law regulations, martial law laws and laws made between 20th 5th of March 1169 and 19 day specific कोई section आप
So law, the law reforms ordinance, the power of making law has been protected by Article 270 by the Constitution.
जी जी
तो जब एक मर्तबा वो power Constitution ने कहा कि ठीक है,
सर ये retrospective protection है
फर्दर के लिए भी है,
पोस्टपेक्टो अप्रूवल थी भाई
फर्दर भी उसको आज तक यूटिलाइज हो रही है वो पावर।
I take your point. I'll move on to the next point. ठीक है? Sir, there I think, and this is where I differ from Mr. Salahuddin Ahmed, I think there are two principles which have to be safeguarded in the context of the constitutional history of this provision, where slowly all executive role has been taken away. This has not happened in India. The executive role is still there in 145. But here, and the structure of the provision itself, where the dominant focus in the Supreme Court making rules. There are 4 limitations on the Parliament making laws regarding practice and procedure. Any act of Parliament under Article 191 Constitution 1973 will be subject to 4 restrictions, limitations. Firstly, the law has to be limited to practice and procedure. Secondly, the law cannot colonize or abrogate the primary role of the Supreme Court to frame rules. So if your lordships come to the conclusion, I don't support the view that Parliament can simply abolish the Supreme Court rules. That will destroy the complete autonomy of the Supreme Court. But if you're...
Can there be an implied repeal? Mr. Salahuddin took the position that they can be expressly repealed. Can there be an implied repeal?
There can be implied repeal, but does that amount to destroying the power of the Supreme Court framing rules? That has to be seen provision by
There can be
provision.
implied repeal. Why can't there be express repeal?
No, there can be express repeal in relation to specific provisions. The third.
So
Thirdly-
what you're saying is that if there is a rule is made and subsequently Parliament can undo that rule by
Yes.
making a law, so
Yes.
then the law will prevail.
Not in every circumstance.
What
And I'll
cir-
explain when I read
How
the
does
third.
that then, how does one understand this second point of yours?
By the third
That it
point.
does not abrogate the role of the Supreme Court?
By the third point.
Which we are awaiting to hear.
Thirdly, no provision of such law can violate the constitutional provision of the independence of the judiciary. So your lordship has to look at every provision and see whether the repeal which has taken place of a particular provision impacts the independence of the judiciary or not. That is the method, and that is the thing which has been laid down in a Supreme Court judgment, will I judge side. The fourthly, no law can restrict jurisdiction or powers of the court on a harmonious reading of entries 55 and 58. So there is, these are the limitations on Parliament.
What about separation of powers? What about the constitutional principle of separation of powers? I find that missing over here. Why should that not be also a limitation?
My lord, I take that within the notion of the independence of the judiciary, at the heart.
That's a separate thing.
Learned Counsel.
They're two separate things.
Separation of powers is not restricted to the judiciary.
Yes.
What if the judiciary starts encroaching upon the powers of the legislature and
चले
executive?
पांचवा डाल दी
And
क्या
that
फर्क
is
पड़ता
how,
है? पांचवा डाल दें क्या फर्क पड़ता है? कोई फर्क पड़ता है?
so I mean, there's a system of checks and balances
Yes,
as well.
yes.
So the Parliament is empowered to legislate. And all that they have legislated is something which ensures access to justice.
That is what I will show when I come to provision by provision, that none of these provisions.
Can you elaborate a bit more on your second one? The court cannot colonize or abrogate the primary role of the Supreme Court to frame such.
My lord,
Kindly elaborate a bit more.
example of that is the Bas Kakar case. It's a classical example as to why the Supreme Court struck down that law. What in the Bas Kakar case, what the Contempt of Court Act 2012 did is that in terms of actual cases pending before a particular judge, in which that judge had taken cognizance of, for example, a contempt on the face, in that, legislature interfered and that said that that case will go before another judge.
That's not practice and procedure. That's not
No,
practice.
but
and
I'm saying that is that.
No, but Bas Kakar was decided in the context of Article 204.
No, I'm giving you an example.
But that was a different context. Give me an example of 191 when you say
I'll give you an example.
colonize or abrogate.
I'll give you an example. Let's let's take section 2. If there was any rule,
आप जरा specific example नहीं, मुझे जरा पहले इस principle को जरा समझाइए।
वही मैं principle-
आपकी limitation
मैं
क्या
एक
है?
example से principle को, let's say that section 2 envisaged some kind of role of the executive in the constitution of the bench. That I would say would be a violation of 191 and the principle of the independence of the judiciary.
I would regard section 2, I mean section 3 actually.
सेक्शन 2 सर कमेटी जो बनती है उसमें एक कमेटी मेंबर चीफ
3 में है ना?
जी
3 में है?
2 में है ना, 3 में तो वो है ना सर मेंटेनेबिलिटी वाला सर.
Sorry, 2 में है. I would regard that as colonizing the.
I know your lordship comment about
you used very interesting words.
Colonization.
Colonize, तो colonize.
बस ये लिटरेचर पढ़ के थोड़ी सी गलत
Colonize हो गया ना इसके अंदर. इसलिए मैं आपसे ये you're making an interesting point, but I want you on the plane of principle kindly to explain this point further.
Sir, this cannot be preemptively elaborated. This can only be understood through example because one doesn't know. Your lordship has to examine this provision by provision. That is why what I would be suggested that there is a debate between that we should open the door and not be afraid of it, and there is a suggestion about closing the door. I would say keep the door open, but there should be certain padlocks on it.
नहीं उसके अंदर
No, but the other way is that you keep the door open, but the watchdog is sitting.
Yes.
And watchdog ensures that nothing, fundamental rights are not violated. So all your 5 points could be summed up by saying that as long as that law doesn't violate the fundamental rights, which includes access to justice, independence of judiciary.
Siddiqui
आप
साहब-
ये जो आपने बात की है second, ये आपका जो
Siddiqui
second है, how
साहब-
does that square with the implied repeal? आपका ये जो second point है ना?
जी.
Secondly, the law cannot colonize or abrogate. आपने अभी कहा कि implied repeal is possible.
Yes.
Kindly explain to me
Sir.
how.
जी.
As a principle,
sorry.
principle की बात
Sorry,
करें ना. I mean, don't go into the nitty-gritty right now. वो तो आप आगे जाके करेंगे. मैं आपका principle समझ रहा हूँ. How does this square with the? You say there can't be express repeal. But how does this square with implied repeal?
No, sir, there can be express and implied. What Mr. Salahuddin argued that the parliament can get rid of the entire Supreme Court rules. I'm not advocating that on a particular rule.
How do we identify the core that cannot be repealed?
Yes.
Mr. Faisal, the core would be that in case, Mr. Salahuddin might be correct, you see, they can strike down the entire set of rules provided they don't violate the independence of judiciary. Your argument is the same.
No,
So I stand on any provision. Suppose theoretically speaking, if you bring out a law which takes away all the rules that are there, but it doesn't affect the independence of judiciary, maybe enhances the independence of judiciary, what's wrong?
My lord, I think what is underlining 191, and this is something which should be safeguarded at all circumstances, is at the heart of 191 is not the law made by parliament, but the internal autonomy of the Supreme Court.
There has to be some
Siddiqui
principle.
साहब, my question, please.
जी, जी, जी.
ये आर्टिकल 191 की जो लैंग्वेज है that starts with subject to the law in the constitution. There are very few articles of the constitution which starts with the word.
There are only 3.
Only 3. Yes. So does it means that because the constitution was framed in 1973 and the rules were framed in 1980, do you think that there is still a room is left for the improvement in the procedure with the passage of time? Like 184(3), whenever it has been used, ये पूरे मुल्क की बुनियादें हिला दी उसने जब भी इस्तेमाल हुए. So do you think there is a room left for improvement in Article 184(3) or the procedure of the Supreme Court?
My lord, I think
Intentionally that has been done.
whatever amendments, and I'll take your ladyship through each of the amendments, whatever amendments have been done, I think that shows that reform is required under Article 184(3).
तो can I just understand, आप ये कह रहे हैं कि 191 enables Parliament to make law.
Yes.
The principle to apply will be the independence of the judiciary. So the independence of the judiciary and the ability to make rules should be protected and preserved. But Parliament can make law with reference to practice and procedure.
Yes.
If they do make that law with reference to practice and procedure, so that's not undermining that principle of independence of the judiciary, but then we then go into the provisions that
Yes.
they'll start making of practice and procedure, and so then see whether that meets the
Yes.
test. So then my question is that isn't the constitutional mandate the opposite? Isn't the constitutional mandate saying that the Supreme Court, to the extent of how it regulates practice and procedure,
और यहाँ हम खबर आपको दें, पीटीआई ने लिबर्टी चौक लाहौर में जलसा की इजाजत के लिए हाई कोर्ट में दरख्वास्त दायर कर दी है. दरख्वास्त एडिशनल सेक्रेटरी पीटीआई पंजाब अजीमुल्ला खान ने दायर की है. दरख्वास्त में डिप्टी कमिश्नर लाहौर समेत दीगर को फरीक बनाया गया है. इसी बारे में तफसीलात जानते हैं नुमाइंदा एबीएन न्यूज़ असद शाह से. असद शाह, बताइएगा इस दरख्वास्त से मुतालिक.
हाँ जी बिल्कुल, मैं आपको आगाह करता चलूं कि पीटीआई की लिबर्टी चौक लाहौर में जलसे की इजाजत के लिए लाहौर हाई कोर्ट में दरख्वास्त दायर कर दी है. दरख्वास्त एडिशनल सेक्रेटरी पीटीआई पंजाब अजीमुल्ला बगोड़वी ने दायर की है. दरख्वास्त में डिप्टी कमिश्नर लाहौर समेत दीगर को फरीक बनाया गया. मुल्क में अनकरीब आम इंतखाबात होने जा रहे हैं. पीटीआई इलेक्शन के लिए अपने मंशूर का ऐलान करने के लिए जलसा करना चाहती है. दरख्वास्त में ये मौक़िफ़ अख्तियार किया गया और दरख्वास्त में मजीद मौक़िफ़ अख्तियार किया गया कि डिप्टी कमिश्नर